continued to be governed by the Mukul Devangan regime, namely that those will not be considered a ground for invalidation of the insurance policy, because they were driving cars on the basis of the binding judgment of the Supreme Court. But, my lord, the matter has been referred by 3 judges to 5, and it is an issue of law. It is an issue of interpretation of a parliamentary enactment. The government, whether it agrees or does not agree, my lord, cannot change a parliamentary enactment. That's the executive government. Ultimately, this call has to be taken by parliament. But as it stands today, once the reference has been made to your lordship, then, my lord, it is my humble submission that your lordship must answer that, my lord, reference. Your lordship may say that we agree with Mukund Devangan, or your lordship may say, no, Mukund Devangan was wrong. It did not consider various aspects of it, and at the same time protect, my lord. So therefore, my lord, to ask the government will not be able to tell your lordship that they want to amend the act or whatever it is. Ultimately, that's a call that parliament has to take. And therefore, my lord, your lordship will have to interpret the law that is presently there before your lordship, my lord, in terms of the Motor Vehicles Act with the amendments. And, my lord, it is far more dangerous. The legislature took a clear, according to me, my lord, if I'm right in the interpretation of the act, the legislature took a clear distinction between transport vehicles and light motor vehicles, and laid a completely different regime. Your lordship recalls, my lord, that second part of section 3(1), which says that no person shall drive a transport vehicle without specifically being authorized to do so. So therefore, in my humble submission, my lord, it is far more dangerous to let people who do not have that endorsement of permission to drive a transport vehicle, or do not have, my lord, a license to drive a transport vehicle, because the longer this continues, the more, my lord, drivers who are not properly equipped to drive a transport vehicle will be on the road. The earlier your lordship decides this issue of whether they are actually equipped or not, the better it is. Ultimately, I follow, my lord, your lordship is concerned about people who are insured who may be left without insurance, but that is at the stage when there was confusion because of Mukund Devangan. That your lordship can take care of under 142. But your lordship should not, my lord, let this issue linger. If the position of law is absolutely clear, it is of course open to parliament to later on amend it if they feel that it is wise to amend it. But for the moment, whatever the act says, and it is my humble submission that the act has always said the same thing, namely, my lord, section 3(1), that second part has always been there. Section 10 amendment, whereby transport vehicle has come as a separate class of vehicle for which a license can be granted, came in 1994. But even prior to that, that second part of section 3(1) was always there. Therefore, my lord, in my humble submission, Mukul Devangan is an aberration. It's a departure from, my lord, what the act says, and therefore it needs to be corrected at the earliest, because it is resulting in people who are not equipped to drive a transport vehicle being permitted to drive a transport vehicle.
Only one interjection, apropos what my learned, it fell from him. I'm not objecting to that, just to appraise your lordships. If your lordships takes the referral order dated 8th March 22. Lord,
just 1 second.
Your lordships may perhaps not be required to rely upon 142. That is taken care of, subject to my understanding being corrected. Para 7 of that order, last but one para.
The referral order.
Before we part, we must note that all the learned counsel appearing for the insurance companies have fairly submitted that the compensation in terms of the directions issued by the courts below, that is to say, in following the principle laid down in Mukul Devangan, has either been paid in full or shall be paid in terms of such directions. Their statements are recorded.
This can continue.
Which justified the interpretation. This is what I say in all humility. A validation act or a change in law would be required if it was to remove the basis of a judgment. Here, the interpretation of the act itself is patently on the face of a draw.
You're absolutely right. There's sometimes when a new law is required to take away the basis of the judgment. assuming, of course, we know your point that Devangan is basically wrongly decided, therefore it has to be set it right on interpretation. But we are also of the view that the government must now consider whether the position in Devangan should continue, whether it should be modified in part, whether, there is some change in the law required, bearing in mind the sectoral changes which have taken place, the impact of the judgment being reversed broadly on the social sector.
Sectorial changes that have
Therefore,
occurred.
That no one can, if your
That's
lordship
right.
feels so, that's the larger issue.
so
But
we are
all
not
that we are-
closing the reference.
All that we are
First of
adding
all,
on-
we'll not close the reference
Yes.
saying that, look,
I-
we are not saying that, look, Devangan is, that Devangan is rightly decided. You don't want to do that.
Now down.
Because then you would be doing disservice to the reference order.
May I with respect say, our concern was what? As far as the
Government
compensation
still
is
tell us that, no, you decide whether Devangan is right or wrong. We don't want to bring any change in
The
the law.
compensation was concerned, the learned Solicitor General has shown para 7. My lords, as far as livelihood is concerned, our respectful submission right through has been, all it requires is meeting the eligibility test, and in the meantime, a window can always be given by the court. But the impact of permitting a person who is ineligible and ill-equipped to drive a transport vehicle is far more. It's not a simple.
But I'll tell you
interpretation.
one thing, see, that is to be seen.
That
See,
is to be
Mr. Both
seen, that's
Mr. Jan Bhushan also, and you are saying that all that it requires is an endorsement. Now, the point of the matter is that the government may still come to us, for instance, I'll give you an example. The government may come to us and say that, look, you are right, the insurance companies are right. We must make sure that all existing licenses fall in line with the rigor of the statute and the rules. But at the same time, the government can still bring about a suitable amendment by saying that, look, existing licenses will be protected for a period of 3 years. We can't do that. I mean, for us to do that under 142 would be a little far-fetched after we lay down the law. Government can still say that, look, we want these to be in conformity, but we'll give a little time for bringing about this end.
That's what we should do.
My lord,
The license will remain valid for LMV. The only question will be, the statute as we read it says that it's valid for LMV and endorsement for transport. It is the Devangan interpretation
Right.
which does away with the distinction between a light motor vehicle purely for non-transport use and commercial use. That's where the rub lies. So it's not as if someone loses the license. What your lordships are saying is an issue where post the judgment, people may have acquired a license, started commercial activities. For those, what we are saying, windows can be created.
Or
But
even
sure-
see the judgment.
Lord,
The
may I
judgment,
just
the
supplement?
statute was clear. The parliament was clear, including the learned attorneys' written submissions now before your lordships. The
So,
intention
we'll
of
have to-
parliament has always been.
Suppose, therefore, we accept your argument and say Devangan was wrongly decided. We'll have to first use our 142 power to say that existing claims for compensation will be governed by the law as it was enacted, law as it was interpreted in Devangan. Two, we will have to say that, look, those licenses which are no longer valid as a consequence of the reversal of Devangan, they can yet, we will treat them by deeming direction of the court that they will be still treated as valid licenses for a certain stipulated period, say 6 months, 1 year, to for people to acquire endorsements. You're not dealing with, one big industry or, one source that you can exercise the 142 power. You're dealing with lakhs and lakhs of people, who have licenses.
And
Let the
Devangan,
government decide what to do in such
My
a
lord,
situation.
Devangan actually inured to some amount of social benefit. Then the negativity of Devangan, how it negatively impacted is also a matter of deliberation, which the government will look into it, how it has worked over a period of time.
my
And
lord,
they
we
will
are
have to
yet
look
to
into
argue
it.
on merits, my lord. If my lord is making any observation on merits, we are yet
Should we
to.
make any observations, merit? We'll not do
Secondly,
anything
my lord,
like that.
secondly, even if it,
We have
my
to
lord is,
still, we have to still consider a response from your side on merits. That
Yes.
we will not do. We are just looking at the broader.
and even if my lord is referring it to government, my lord may put adequate safeguards, because any such reference or any observation regarding Devangan, before High Court and tribunals, it is read that it will be reconsidered, to be changed, and entire litigation comes to standstill across country. My lord may put in adequate.
Lord, may I just make two short submissions, my lords?
We are not carrying on merits on the correctness
Yes.
of Devangan. We are not taking the matter beyond the referral order of 8th of March 22. We are not going back on the referral order of 8th of March 22, and we are holding, we will hold the position as it is on the basis of the referral order.
Milords, may I just make one or two short submissions, Milords? There is a slight difference from what has been suggested to your lordships or argued, Milords. Devangan has been referred to your lordships on the ground that it is per incurium, actually, not that it wrongly decides, because it does not consider.
Right.
It does not consider certain provisions of the Motor Vehicles Act while it gave that interpretation. So it's not an interpretation per se which is before your lordships, my lord, that these sections which were not considered by Devangan therefore makes it per incurium, which is, your lordships will find at page 114, the paragraph before the court, my lords. Thereafter, certain provisions were not brought to the notice of the court deciding Mukund Devangan. Those provisions as quoted in the reference order are under, and therefore it comes, my lords. So therefore, it makes the judgment per incurium according to us, my lords, and therefore, once these provisions are taken into account, it will obviously, my lords, on a question of interpretation would be entirely different because they were not considered in that judgment.
That's the only point I am making. Save Life Foundation, my lords, is the only judgment of this court, my lords, till now, where, my lords, road safety is considered as a part 321 right. And, my lords, if your lordship slightly look at the present attorney's note also, it talks about public interest, my lords, in paragraph 6. Therefore, my lords, keeping in view public interest in paragraph 6 that has already been spelled out by the government, as well as, my lords, this judgment, my lords, namely Save Life Foundation, where it clearly says in paragraph, my lords, 57, page 208, that the integral part of our constitutional scheme under 21 is road safety. There is no other judgment, my lords, which comes quite close to this as far as road safety is concerned. And pursuant to this judgment, my lords, 134A was included. So, my lords, therefore, pursuant to this judgment, 134A, wherein, my lords, witnesses protection program has been given, has been included. Therefore, based on that, my lords, they can always come in with a new change of law. But the point is, my lords, both this judgment as well as paragraph 6 note, which my learned attorney has given, may be taken into consideration. The lordship may say that it has been made part of the 21 right. Therefore, the law could be brought in terms of that. The lordship may kindly see, my lords, 2016 7 SCC 194. 2016.
That's right. If you have to assist the court on second one.
A reference before the Constitution bench arises in pursuance of an order dated 8 March 2022 of a bench of 3 judges. Full stop. The bench of 3 judges, the 3-judge bench, was in turn getting a reference by